Karibu sana mtazamaji na msikilizaji wa Celeb Corner KE from whatever part of the world that you're watching us from. The case of Rigathi Gachagua against the Senate, the National Assembly and the Attorney General of the Republic of Kenya seems to be a case that is taking a new turn. Now, according to the latest report and the latest information that we are receiving, it seems that Chief Justice Mother Koome has thrown Rigathi Gachagua under the bus. What I mean under the bus is that Chief Justice Mother Koome, who was expected to spearhead the said case about the Deputy President of the Republic of Kenya's impeachment, seems to have taken a backseat. And a letter from Rigathi Gachagua has currently been leaked via social media, which is a direct address to the High Court. A letter which is dated 20th October 2024, yesterday. The Deputy Registrar, High Court of Kenya at Nairobi, Constitution and Human Rights Division. Dear Sir, reference, High Court Constitutional Petition number E565 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly, the Speaker of the Senate, and the Attorney General. Now, I read the said letter addressed to the registrar, the Deputy Registrar Office, the High Court of Kenya at Nairobi. It reads, we act for His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, herein after referred to as our client, who is the petitioner in this matter. Our instructions are to write to you and address you as here under. Number one, upon filing petition E565 of 2024 on 18th October 2024, the file was placed before Justice Chacha Mwita, who then issued a conservatory order staying implementation of the resolution passed by the Senate removing our client from office by way of impeachment. The judge further directed that the file be placed before the Honorable Chief Justice of before the Honorable Chief Justice to constitute a bench of an uneven number of judges to hear the petition. The judge further directed that the matter be mentioned before the said bench on 24th October 2024. Now, on second, having certified that the petition as raising substantial questions of the law, public interest, the same ought to be dealt with in accordance with Article 165(4) of the Constitution, which provides as follows. Any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an uneven number of judges being not less than 3, assigned by the Chief Justice. Number 3, it is noteworthy that in petition number 522 of 2024, in which the Honorable Mr. Justice Lawrence Mugambi certified that the petition raised weighty issues and directed the file to be forwarded to the CJ or Chief Justice to constitute a bench of an uneven number of judges in exercise of his constitutional duties and functions under Article 165(4). A bench of 3 judges was constituted, comprising of Lady Justice Frida Mugambi, Justice Eric Ogola, and Justice Anthony Murima. Now, communication to that effect was sent from the Office of the Chief Justice to all counsel representing different parties in the petition. The said communication informed the advocates on record that the Chief Justice had discharged a mandate and that they were required to appear before the 3-judge bench. Number 4, in the particular case where at around 1:35 p.m. on Friday, 18th October 2024, Justice Chacha directed that the file should be remitted to the Chief Justice, we demand to know the following. Number one, whether the file was actually taken to the Chief Justice and at what time. We are dealing with constitutional functions under 165.4, and the Chief Justice appreciate that these are matters of record, and that is why constitution of the bench is recorded in the respective file. Number two, whether indeed there are directions recommended in the file constituting the bench, which then proceeded to issue directions on Saturday 19th October 2024. Now, continuing, the reasons for our demands above is that on Saturday 19th October 2024, an application was filed, and though we were not notified about the bench being constituted, we now we have now been served with orders issued by a three-judge bench. To the best of our knowledge, this bench, constituting of Justice Ogola, Justice Murima, and Lady Justice Mugambi, had only been reconstituted to hear other petitions consolidated under Nairobi High Court petitions number 522 of 2024, and not the instant petition. Number 6. The three judges bench delivered a ruling on Wednesday, 16th October 2024, dismissing the petitioner's application seeking conservatory orders in Nairobi High Court petition number 522 of 2024 after delivery of the ruling on behalf of the petition. The undersigned pleaded with the bench for a mentioned date on 18th October 2024. The request was, however, denied on the basis that the earliest date available to the court for mention was 29th October 2024. Now, in a surprising turn of events, the same bench was able to convene very hastily on Saturday 19th October 2024, and upon considering an application filed by the second respondent dated 18th October 2024, it issued directions that the second respondent application seeking to set aside the conservatory orders issued by Justice Chacha Mwita shall be heard on Tuesday, 22nd October 2024. Now, the judges further considered and issued directions in Kerugoya High Court petition number E015 of 2024, and issued similar directions for hearing on 22nd October 2024. Essentially, it is important to note that the same judges who declined the petition's request for an early mentioned date in Nairobi High Court petition number 522 of 2024 have now issued a hearing date of 22nd October 2024 in the instant matter, which had been scheduled for mention on 24th October 2024 in accordance with the directions issued by the Honorable Justice Chacha Mwita. Number 9. We have received an email from counsel for the Attorney General indicating that Kerugoya High Court petition numbers E015 of 2024 and Nairobi High Court petition number E565 of 2024 have been consolidated. Kindly confirm whether indeed the two matters have been consolidated as indicated. As counsel of the petitioner in Nairobi Court petition number E565 of 2024, we have not been heard on the issue of consolidation, and it is very strange that the petitions can be termed as such. It is therefore not clear when and how the two petitions were consolidated, if at all. Number 10, inalienable requirements of fair trial dictate that justice not only be done, but also that it must perceptibly appear to be done. To the contrary, in the instant matter, there is a clear case of bias in the manner in which the petitioner is being treated. It is also evident that the jurisdiction of the Chief Justice is being surpassed. The lightning speed with which the Kerugoya file was grabbed and directions were issued on Saturday seems like a well-orchestrated plan to trample on the rights of the petitioner by denying him a fair trial right from the National Assembly all the way to the Senate and now at the Judiciary. Number 11, an insight into the introduced and relentless effort to have the conservatory orders set to aside were reported in a newspaper article titled Behind the Scenes Power Play that derailed Kedora Kindeke installation. Published in the Daily Nation on Sunday, 20th October 2024, in the article, it was reported inter alia that until 9:30 p.m. on Friday, the planned swearing in of Professor Kedora Kindeke as the next deputy president was on course, but dramatic developments that revealed a high-stakes power play would derail the ceremony. As soon as the state law office learned of the orders earlier that afternoon by a Kerogoya court stopping the swearing in of Professor Kedora Kindeke, top officials led by Attorney General Dorcas Oduor were quickly summoned and instructed to prepare a defense to counter these orders. It was exactly at 3 p.m. the team of lawyers from the AG, the Attorney General's chambers, were instructed to swiftly move to the Court of Appeal in Nairobi to seek the reverse of the directive and that was stalling the quick replacement of Mr. Rigathi Gachagua after the Senate had voted to remove him from office as deputy president. But just before the start of the 9 p.m. bulletin on Friday came the news that collapsed all the efforts by the state to swear in Professor Kedora Kindeke on Saturday. At the Court of Appeal in Nairobi, the government lawyers, led by the Attorney General, had failed to secure the orders to overturn the decree barring the ceremony. The team from the state law office had failed to convene the appellant judges that was a need to sit outside working hours to set aside the orders by the Kirinyaga High Court. Multiple sources familiar with the matter told Nation Africa that the judges were hesitant to sit outside the office hours unless authorized by Chief Justice Mother Koome. This directive by the appeal court judges triggered a flurry of calls seeking how the CJ to convene the appeals judges to hear the matter. Both the CJ and the Deputy Philomena Mwilu were, however, unavailable. The sources said the CJ had traveled out of the country and could not be reached on phone. A copy of the article is attached for ease of reference. Number 12. We have instructions from our client that Honorable Oscar Sudi, Member of Parliament for Kapsaret constituency, who is a close associate of the President and a prime mover of the impeachment motion, has been quoted in the media stating that Professor Kedora Kindeke will be sworn in as Deputy President of the Republic of Kenya at 10 a.m. on Tuesday, 22nd October 2024. By its conduct, in moving the date from 24th October 2024 to 22nd October 2024. The three-judge bench appeared to be dancing to the tune of Honorable Oscar Sudi. This unholy union is highly prejudicial to our client. This conduct sends shivers and trepidation to our client on whether there is any prospect that justice will be administered in his case, given that the bench now appears to be part of the National Assembly and the Senate. In the meantime, we are instructed to request that an investigation to be launched to establish how the file Nairobi High Court petition number E565 of 2024 moved from the Justice Charter to the three judges without express directions from the Chief Justice. There are preliminary indications that the Chief Justice was not even in the country at the material time in question. The reason a formal complaint is being filed with the Commission, with the Judicial Service Commission. We have sent a copy of this letter to the Chief Justice, from whom we are seeking a written response on the issue raised herein. Please revert. Yours faithful, Kamodo Jomo and Company. John Jomo. Hey, the Honorable Chief Justice, Republic of Kenya. These are some of the people that are named: the Chief Registrar of the Judiciary, the Honorable Attorney General, GA and G&A advocates, Ndegwanjiro advocate, Kiragu Wabuta advocate, Simon Mboro advocate, Lempa Siyanka advocate, Adromoge advocate, the Speaker of the Senate and Senate, the Law Society of Kenya. Now, this is a letter that is dated 20th of October, which was yesterday on Sunday, addressed to the Chief Registrar of the High Court. Now, this letter tries to tell us what is really happening at the judiciary right now. That it is in question that Gachagua might not get the justice that he deserved. Because even the bench of judges that has been conveyed to hear the case, the impeachment case that is supposed to happen tomorrow, which is on Tuesday, is the same bench that listened to a petition filed at the High Court to stop the proceedings at the Senate. But these same three judges overturned the petition and ruled it out. And now they are being given the opportunity again to meddle in the matters which they themselves were unable to settle for the first time. That is why Gachagua says, it seems even the Chief Justice of the Republic of Kenya has thrown me under the bus. Remember, the same bench was asked if they would move the case to the 29th of October so that it can be determined then and proceed to the Senate and the National Assembly to give the Gachagua team time to prepare for the case. But they refused. They said that they were asked to give a earlier date to Gachagua and the team, where they went ahead to claim that we don't have any free slot as the judiciary right now and the High Court. The only free slot and time that we might get is on 29th of October. Now, Gachagua and his team are asking, where did they find the time to convene a meeting on Saturday 19th, decide that the said case will be determined tomorrow on 22nd of October? That is the question that Gachagua and his lawyers are asking. And he claims that these judges, the bench of the three judges, has been nothing but a kangaroo court also. It seems that they have joined the Senate and the National Assembly and the Attorney General in trying to persecute him. Yet they themselves are supposed to offer a fair trial, which seems that Gachagua won't get justice as he deserves. Now, the Chief Justice of the Republic of Kenya, not only also assistant, that is Philomena Mwilu, the Deputy Chief Justice, they are also said not to have intervened in this matter. They have not convened this bench of judges. The bench of judges has just taken up the matter into their own hands through the High Court, as they did earlier in the case of the petition by Rigathi Gachagua. Because yes, they were convened before even the case proceeded to the Senate. But they took the matter, quashed the petition, and proceeded with the case. Now, when the case has been returned to them again as unfair, they have taken it again. The same bench of judges that was supposed to deliver justice before and failed, it's the same justice that is supposed to deliver justice now. Tell me how this man is going to be to get justice. The Chief Justice of the Republic of Kenya, Honorable Mother Koome, has failed to even sign. Now, the reports and intel that we are, Chief Justice Mother Koome is said to be drafting a resignation letter because she believes that she will be forced to swear in Kithure Kindiki, which will be against the Constitution of the Republic of Kenya. Now, she believes if that might happen, and if that happens, she will not be fit to continue holding office as the Chief Justice of the Republic of Kenya. She will be forced to leave the office because that office will prove that it cannot offer justice to the people of the Republic of Kenya. Now, that is where we say the Constitution of the Republic of Kenya and the law of the Republic of Kenya, the law and order that is supposed to govern our country will have been fed to the dogs. If they can go behold the Chief Justice to make sure that Kithure Kindiki is sworn in, then what do we have as the judicial system? It's a corrupted institution. I leave it there for now. I remind you that this is Celeb Corner KE. Please make sure you subscribe to our YouTube channel for more news and more stories.